Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology and IP transactions and keep you up to date on the latest trends in growth and innovation, digital transformation, IP and data monetization, and operational improvement by drawing on the perspectives of practitioners who have executed technology and IP transactions around the world. You can subscribe to the show on all major podcasting platforms. We hope you enjoy the program.
Hello and welcome to Tech Talks. Our topic today, Unpacking the China Data Laws. I'm your host, Julian Dibbell. I'm a senior associate in Mayor Brown's Technology and IP Transactions practice. I'm joined today by Gabriela Kennedy. Gabriela is a partner in our Hong Kong office and head of the Asia IP and TMT group. She is also co-leader of Mayor Brown's global intellectual property practice and a member of the firm's global cybersecurity and data privacy and technology and IP transactions practices. Gabriela, welcome back. I know you were on the podcast just about 2 years ago to talk to us about China's data laws and their potentially global impact. At the time, the first of those laws, the so-called cybersecurity law, had been in effect for 4 years, and it was just being joined by the data security law, the DSL, and the personal information protection law, PIPL, both of which took effect in late 2021. So these were all relatively new laws at the time, and so I'm hoping that today you can give us a more informed update now that the world has had a couple of years to live with these laws and see how their effects are playing out and how they're interacting with each other. But I guess we should probably start with a brief refresher on the basics, if you could help us out with that. What are these laws and what do they each cover?
Thank you, Julian, and thank you for inviting me back to be a guest on our podcast. These laws are very, very interesting. CSL, as you noted, came into effect in June 2017, and together with the DSL, the data security law, form a framework around the security of data that is collected in China. So basic and in very simple terms, think about it as all the business data that is being collected by a company during the course of doing business. And you might ask, well, I've had the CSL, it came in June 2017. And why would I need a data security law? What is that adding to what I already have on the books? CSL was focusing mostly on electronic data, while DSL does a sweep all and catches analog data as well. The personal information protection law that came, the PIPL that came in November, focuses largely and entirely on personal information. Interestingly enough, CSL, prior to PIPL, had some provisions that dealt with personal information. So the question now is, what do you do with those provisions that existed under CSL? Are they swept under the carpet? And am I just looking now at what is happening under PIPL? That imposes obligations that are known for anybody who does data privacy or has had to worry about data privacy for their companies relating to data controllers, though interestingly enough, the terminology in China is slightly different. A data controller, confusingly, is called a personal information processor. But for the purposes of this talk, I'm going to refer to them as data controllers because that is a term that is more known to our listeners. So they have different purposes, these three pieces of legislation. The first two, as I said, provide a high-level framework that relate to the security of data, cybersecurity and security of data, and impose certain restrictions on what can be done with that data, whether or not it has to be localized or not, and if there are possibilities to transfer that data across borders, what would be the conditions for that to happen. And personal PIPL really gives a comprehensive framework for the protection of personal information with some known elements that really relate to international concepts, but there will be very Chinese characteristics applied to them. So I hope this answers your question.
Sure, but is there then, there are three separate laws, but there's clearly some overlap among them. Is that correct?
There is overlap, as I said. The CSL and DSL relate to the security of data, and they relate to personal and non-personal data. They have some overlap in terms of some of the concepts that are used. You will, when you read these laws, come across terms such as important data, core national data. So those, terms keep appearing in DSL and CSL, but they are different explanations for them. So these terms are deliberately vague because they can be very malleable. And in fact, it was only towards the end of last year that we had some clarification in the guise of some, guidelines vis-a-vis how the officials are going to interpret the definition of core national data versus important data. There are certain commonalities in terms of requirements of what companies need to do to prepare and to ensure that they have a stable framework that would not damage and affect the national security. So that relates to a multi-level protection scheme. So every company has to determine where they are in terms of their level of security risk should an incident occur. And that is something that appears under both DSL and CSL. And we also have certain commonalities, as I said, in terms of, purpose and scope. So three areas: purpose and scope, some definitions and concepts, and some requirements that carry through some of these legislations. So the whole, point that I would like to make here is you cannot look at these laws in isolation. So if you're a company that tries to comply with data laws in China, do not focus just on PIPL, right? So what has happened since PIPL has come into force was especially for foreign companies that had already a heightened understanding of data privacy regulations internationally, they zoomed in and tried to focus on compliance with PIPL, forgetting about compliance with DSL and CSL. And these legislations are intertwined. You cannot look at them in isolation. And you must remember that the regulator under these three pieces of legislations is the same. So should an investigation occur for a breach under one of the laws, the investigation can extend to compliance under the other laws.
Mm-hmm. All right. Well, so there's three laws. They interrelate. I mean, that there's a certain amount of complexity there, but they are laws. They're written down. We had all, we saw the letter of the law even, 2 years ago when you were with us last. But, what we're hearing is, nonetheless, despite, you can go read the laws and in theory know how to comply with them, it's actually turning out to be fairly difficult in practice to comply with these laws. Why is that?
Many reasons. The first is the fact that the laws, as I said, are very vague and broad. So you're expecting to have some guidelines and clarification to know exactly how compliance is going to take place, because there are fine details on what filing requirements you have, and there are many. So there have been piecemeal guidelines and regulations. And what made compliance very difficult was the fact that these were issued as, let's say, draft measures or draft guidelines, and they stayed in draft for months and months and months, sometimes 10 months, 11 months before they were finalized, which left, a big question mark to companies. How am I going to comply in the meantime? I know I have the idea of what I need to comply with, but I don't know the specifics and what exactly I need to do. So the advice, and the wisdom, had been up to the point where an actual guideline gets finalized to try and comply by looking at the draft as much as you can. I also mentioned earlier that there are very vague definitions, so it's difficult to know. Am I going to be categorized as a critical information infrastructure under CSL? And when I say critical information infrastructure, normally people think of electricity grid, telecommunication company, big infrastructure, companies. Or am I going to be a network operator, which is everybody else? Everybody else is connected to the network. Am I collecting data that is important data? Well, I don't know, because that definition and that the way a regulator will look at it will depend on a economic context, geopolitical context, the weight of my business, in that country. It can change. And as I said, we've just had some measures that clarify that to a certain extent only in December last year. And the most difficult point and bit for most companies has been the multi-level protection scheme, because that requires a lot of work. You need to do self-assessments, you need to do a third-party assessment, you need to file gradings with the Public Security Bureau, which is like the police. You need to have network governance, and you need to submit an evaluation report. You're not quite sure whether you're on level 1 or level 2. Level 1, level 2 are the lowest levels, and the higher up you go towards level 3, 4, and 5, the more obligations you have. So there's a lot of uncertainty as to where you're categorized. I guess, most companies would want to be on level 1, but in reality, most of them end up on level 2. And then you're having to determine what you have to do in that sense. There was a lot of uncertainty about transfer of data. So probably headline said, China is imposing data localization. Yes and no.
Yeah.
So transfers are possible, but you have to go through a lot of hurdles, right? There are certain scenarios that are permit you to transfer, the data. And, the one that, again, most companies focus on the data privacy laws, on PIPL. And there are 3 ways in which you can transfer data across border. There's a security assessment, and there's obtaining a certification, which is conducted by an accredited body, or the one that everybody's been waiting for, executing a standard contract, because that is something that we understand, we've seen in other countries. We can transfer, we can say, well, I'm used to that, I've done it, it's probably not as painful a process. Well,
these are similar to the standard contractual clauses that we see in EU, US data transfers.
Similar in name, dissimilar in every other respect, because you have to go through a number of processes and things that you have to do. You have to do a privacy impact assessment. You have filing requirements that are quite onerous. There's a whole list of things that you have to file, and there's a deadline. These things, the standard contract has just been finalized, was finalized in March. The actual filing requirements were issued in June this year, and there's a deadline to file your standard contract by the end of November, so by 1st of December. So there's a flurry of activity at the moment for most companies to finalize their standard contracts. But there are still, uncertainties that remain, even with, that, a clarification that was issued in June this year.
So you mentioned a few times assessments, you mentioned certifications, there were potential approvals. How many of these are there, packed up in these various laws
Oh my
in order
goodness.
for companies operating in China to be fully compliant?
Okay, so let me just, very, very briefly, and I hope I don't scare the audience, the listeners too much, take you through some of them, not exhaustive lists, but just some to give you a taste of what you have to do to comply. So under CSL, you have to satisfy the MLPS, right? So that involves assessment, self-assessment. If you're a network classified as level 2. It's a CII operator's assessment. If you are a CII, you have filing requirements. You have a security assessment, as I said, that you have to do. You have an official security assessment that you have to file. Under DSL, if you are handling core national data or important data, you have to have a risk assessment just for that. You have to have a security assessment. You have to have also, in the unfortunate event that you have an incident, you have to go through a data security incident, and if you want to get data transferred out of China, you need prior approval from a relevant PRC authority. So DSL has extraterritorial jurisdiction, as has PIPL, which is very, very interesting. CSL doesn't, but DSL does. And in essence, it stops a company from transferring data, let's say under compulsion of a court order in the US.
Mm-hmm.
That cannot happen unless you have gone through these processes and you have obtained the prior approval of the PRC regulator. So if you have a deadline imposed to you, say by a US court, under in a discovery process, that is going to cause a bit of a headache. And under PIPL, you have security assessments, especially for cross-border data transfers, privacy impact assessments, and those are relevant when you're doing transfers, but also if you're handling sensitive information. So quite a lot of assessment. Some may carry over. So once you've done a self-assessment, and the other thing I would say, some you can do yourselves. Others, they have to be done by third parties. And the third parties, depending on where you are on the MLPS level, might be particular authorized third-party institutions. And there's a list, and you've got to use them.
Okay, that's a lot. But my understanding is that generally these apply to companies operating in China. Is that right?
It applies to anybody who has any company that, certainly CSL, any company that operates in China and is connected to the network, right? So it applies. You're on the grid if there is the ethos of this is, if there is an incident, a cyber incident, obviously it will affect your operations, but will the effect be wider? And that's why the concern over it. DSL, as I said, is about the security of data. It's more protectionist, if you want, about the data that is being gathered in China. And it may be or may not be in response to provisions in foreign acts that relate to access to data that is available in China. Okay, so ring fencing data within national borders, that's the ethos. And PIPL has extraterritorial effect in the sense that if I'm collecting information about individuals who are located in China, so I have a website and I'm offering services and products, even though I don't have a presence in China, but my website is accessible in China, and I'm not restricting access. I am not discouraging conducting business with people who are and offering services to people who are in China, then I'm going to be caught by PIPL. Or if I analyze and evaluate the activities of individuals located in China, then I am going to be caught by that. And there will be a requirement to establish a dedicated entity or appoint a representative within the PRC that is responsible for matters relating to personal data handling in China that I am conducting. So you need to report to the authorities who that entity is that will be your designated entity for the purposes of PIPL.
And that's really just for any company that's doing business with China and potentially handling the personal data of Chinese persons. Well, so all right. So what are then some of the key challenges companies face in trying to be compliant with these laws?
There are many. As I was saying earlier, there are privacy impact assessments required to be conducted under various circumstances under PIPL. Who's going to conduct that? How are you going to do it? PIPL also, you have separate consent requirements for certain types of personal data. So am I talking about minors? Am I talking about others? There are also uncertainties in application. There are nebulous concepts, right? As I was saying, important data, core national security data, and what certainty I may have today about whether or not I collect important data may change tomorrow, depending on the geopolitical context, depending on many, many things, and depending on new classifications that might happen. The cross-border transfer restrictions, are very onerous. So on the whole, compliance has been quite a headache for many companies, and many have adopted a wait-and-see attitude and have looked at what is the general shared wisdom amongst peers, in terms of their road to compliance.
So I imagine, another layer of risk here is in companies who do business with China, they have third parties that they rely on as well for many of their services or products. What provisions should companies doing business in China or with China include in their contracts with these third parties, especially given the extraterritorial application of these laws?
Yeah, so you need to, again, it depends on the sector, depends on what you're doing, but you want to have representations and warranties that say that your Chinese partner does not deal in important data. So you don't want to be caught inadvertently in that. Have they obtained all necessary consents? Have they conducted the necessary impact assessment? So they need to give you a sort of a general warranty that they're in compliance. If we're talking about supply chain, and if they have a third-party access, there are quite strict obligations in terms of reporting an incident. Sometimes it's a matter of a couple of hours, right? So 8 hours under DSL. If you are transferring data, remember that if you're transferring data to a business partner in China, the data that you have transferred becomes all of a sudden subject to the data laws in China. So that's something that you need to be aware of and think of how you're going to frame that contractually to get, protection. So also if you are, many companies will require a standard contract now. So if you're doing business with a Chinese company and they will be transferring some data to you and you're located overseas, they will ask you to sign a standard contract. So
this is the standard contract we were talking about earlier.
Yes, and they are unlike the, what we're used to in other jurisdictions. This is something that is non-negotiable. It's been given, it's been provided, and it's in a form that cannot be changed. So you have to sign the standard contract, or otherwise go through the other two mechanisms for data transfer, which involve a lot of assessment and certifications that nobody wants to do.
All right, so consequences of not complying. What are we seeing so far in terms of enforcement of these laws? What are the risks there?
So let's just look at what the statute says. Basically, fines under CSL, revocation, suspension of business license. Okay, under DSL and PIPL, PIPL has fines that are tied to global turnover, so 5% of your turnover in China, or quite a high fine of 100 million. So the first couple of years under CSL, we saw a lot of enforcement focused on technology companies in China, and the fines were not that particularly high. The one enforcement that caught everybody's attention was the enforcements against Didi, which was fined $1.2 billion US. They had 25 apps that were suspended for the duration of the investigation. And other potential risks of enforcements include being placed on a list in relation to social credit, as a company. And what that means is that your ability as a company in China to get a loan might be affected. Your ability to compete and try to get government contracts or particular kinds of get involved in particular kinds of projects is going to be limited. So the one thing that we've seen recently is a beginning of enforcement against foreign companies that operate in China. And that started about a year and a bit ago when we had Walmart subject to a warning because of certain practices, of their operations in southern China. And more recently, the regulator coming and conducting and beginning investigations and entering offices of foreign consultancies in China.
All right, so be on the lookout, foreign companies. Are there other laws, other regulations on the horizon that companies should be looking out for?
Yes, we've just had last week draft measures on facial recognition and biometric identification, which are quite interesting, subject to another podcast, perhaps. There's also draft regulation on audit measures in relation to personal data compliance. So an audit, depending on where you are and the volume of data that you are handling, that could be annual. We've had interim measures on Gen AI, of course. Everybody's talking about artificial intelligence and Gen AI. And we've had new anti-espionage laws coming in July this year, which will join the data laws now because they also look and focus on the transfer of any information related to national security and interest. So it's an add-on, if you want, to the data security law.
All right. Finally, any other issues that our listeners should be looking out for?
I would say that if you have China facing business operations and you haven't yet started to look at these laws, now is the time to do so. And the first step that a company could take is to at least articulate a roadmap and figure out some of the critical and steps that should be taken. MLPS would be one. And secondly would be looking at the privacy practices and procedures and potentially considering standard contracts.
All right. Thanks very much, Gabriela. Very helpful, very clarifying. We appreciate your insights. And thank you for coming on the podcast today. Listeners, if you have any questions about today's episode or an idea for an episode you'd like to hear about anything related to technology and IP transactions and the law, please email us at techtransactions@mayorbrown.com. And thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayer Brown audio programming, visit mayerbrown.com/podcasts. Thanks for listening.